Suara.
Hey Melissa, how are you?
Good, thank you.
Pak Ali. Pak Ali, apa mau dimulai aja?
Iya, nggak apa-apa.
Apa ya?
Yuk.
Selamat pagi Bapak Ibu semuanya. Terima kasih atas kehadirannya. Saya mohon izin untuk membuka dan memoderatori acara pada pagi hari ini dalam bahasa Inggris. Bu Melissa Crouch ini sangat fluent dalam bahasa Indonesia, jadi mungkin Bapak Ibu jika ada pertanyaan juga bisa ditanyakan dalam bahasa Indonesia begitu. So, Bismillahirrahmanirrahim. Good morning, everyone. My name is Milda Istiqomah, and I'm a lecturer at the Law Faculty, Brawijaya University, and I will be the moderator of today's public lecture. So, although we are in a pandemic situation and it's 9 a.m. in the morning in Jakarta, but we still have the spirit to attend this public lecture delivered by Associate Professor Melissa Crouch. We are very fortunate to have Melissa as a speaker in today's public lecture, and she will deliver her presentation titled Southern Constitutionalism, Southern Constitutionalism, the view from the Myanmar and region. So before we continue with her presentation, I would like to invite Bapak Dr. Muhammad Ali Safaat, the Dean of the Faculty of Law, would like to give a short opening speech. Pak Ali, time is yours.
Okay, thank you Milda. Assalamualaikum warahmatullahi wabarakatuh. Good morning, ladies and gentlemen, especially Melissa. I would like to say some short remarks that this forum. Thank you very much for Milda for initiating this forum, and I think 2 or 3 forums already initiated by Milda. It's like blessing in disguise in this pandemic situation. We can initiate some forum that eliminates the limitation of the place. So we can invite Melissa to give public lecture in this time. And also thank you very much for Melissa that kindly give a public lecture. I just hear about the concept of Southern constitutionalism because maybe before we familiar with the concept of constitution without constitutionalism, and very interesting to hear your lecture in this morning. Again, thank you very much for Melissa and for all of the audience that attend this public lecture. Thank you very much. Assalamualaikum warahmatullahi wabarakatuh.
Waalaikumsalam. Thank you, Pak Ali, for the opening speech. And before we continue with Melissa's presentation, I would like to mention some of the rules just to make sure that our discussion will be smooth. And please, for all of the participants to mute their microphone, and if you have any questions, please write it down in the virtual chat and I will read it one by one after in the question and answer session. And as I mentioned in the beginning, that if you would like to have a question in Indonesian, it's fine because Melissa is very fluent. And then maybe I may to call your names and you can have an interaction with her as well. So Melissa, time is yours.
Thank you, Milda, and selamat pagi, Bapak Ibu kalian semuanya, and particularly thank you to Bapak Dr. Muhammad Ali Safat and also to Milda for the opportunity to speak this morning. I really hope this can be a discussion and dialogue, but what I thought I would do to begin with is to introduce a topic that I think is relevant for all of us at this time, and that's the way in which constitutions and constitutional power is being used in a time of COVID-19. It's fair to say that we live in unusual times, and perhaps never before have we seen constitutional emergency powers and legislative emergency powers being used around the world to address and respond to the pandemic. We've seen curfews being imposed, lockdowns being issued, restrictions on movement, restrictions on public and private gatherings, restrictions on interstate travel or international travel, the closure of borders, public health measures from social distancing to masks, and working from home or doing school at home. And all of these really profound changes raise a lot of questions for constitutional law. And I want to kind of start with a basic question, which is really to ask, well, do these challenges to and for constitutionalism, are they the same everywhere? Or should we be concerned about some of the differences that are arising? And what seems clear to me is that the experiences of how governments are responding to COVID-19 are not the same everywhere. And in some places in particular, the challenges to constitutionalism, that is the challenges to limits on power and the challenges to protections of rights, are really enormous. And what I'm particularly concerned with is the way that pre-existing inequalities or power relations bring an added layer of complexity and difficulty to responses to COVID-19, as well as the way that government responses are to some extent, I think, an extension of pre-COVID-19 illiberal tendencies. Now, as some scholars have pointed out, lockdowns in particular have had a perverse effect across much of the global south, where there are a high number of daily laborers who need to move about in order to seek work and make their living. And these really harsh effects of COVID-19 measures have been seen most vividly in places like India. And we know, of course, that in Indonesia, the response of the national government there was in many ways in reaction to what was happening in India, or was an attempt to say that we're not going to be like India. But in the absence of public health measures moving forward and to some extent a return to business as usual in many countries, that itself poses its own risks. And so I want to suggest that we should be particularly concerned with how constitutionalism is affected by existing structures of inequality and compounded by new forms of exclusion. So let me, I want to do three things today. First of all, I want to talk a little bit about the idea of the global south and why I think it's relevant for constitutionalism. Secondly, I want to talk a bit about this idea of constitutionalism in the global south. And finally, I'll use the case of Myanmar to offer some illustrations and examples and stories of what's been happening under COVID-19, about how law is being used, and about the ways that illustrates for us some of the challenges for constitutionalism in the global south. So let me start with the first step, this idea of the Global South, and what does it have to do with constitutionalism? Now, when I refer to constitutionalism, I'm basically referring to this idea of limits on public power. So that is that a government cannot act as it likes. Power is distributed and separated among a number of branches. And there are some checks and balances on power. There are also protections for individual rights in the form of constitutional rights, and ways to enforce those rights through the courts. And of course, in Indonesia, we see that in the context of the Mahkamah Konstitusi. But clearly there are particular challenges for constitutionalism during COVID-19. And so I want to look at this from the perspective of the Global South. So the Global South, as I understand it, is a concept about relations of power. The use of this term is a way of acknowledging disparities between and within the North and the South in post-colonial contexts, as well as the effects of globalization and the expansion of the rule of law in a neoliberal era. So the Global South encompasses the idea that post-colonial societies face specific disadvantages due to extended periods of exploitation under colonial rule, and therefore major challenges of redistribution. These societies often bear a disproportionate impact of the effects of globalization. And this term, the Global South, is used in quite an expansive way, and so is often used to refer to anywhere from Asia to Africa to Latin America. And this concept of the Global South is something that scholars from across a number of disciplinary fields have found useful. So scholars in sociology, scholars in criminology, in anthropology, and regulatory studies have all focused on this idea of the Global South as a useful way to understand some of what's going on in that part of the world. Now, this attention builds on early developments in post-colonial studies and subaltern studies that is about both rethinking history and bringing to the fore voices from the margins. So there are some scholars like John and Jean Komaroff who talk about theory from the South. There are others like Raewyn Connell who talks about Southern theory. And then there are other scholars like Said Farid Alatas who talks about alternative discourses in the social sciences. And I guess what I share with these approaches is this emphasis on learning from the Global South and understanding its experiences on its own terms as a means of reflecting on the state of the North and the relationship between the North and the South more broadly. And as I've mentioned, this idea of the Global South is also tied to histories of colonialism and legacies in the wake of such exploitation. And what it emphasizes is that there are distinctive forms of knowledge yielded by focusing from the Global South, that the Global South is not just a site of extraction, but a source of wisdom and learning. So let me come now to the second part, which is to talk a little bit about this idea of Southern constitutionalism or constitutionalism from the Global South. Now, when I refer to Southern constitutionalism, I'm talking about an approach to comparative constitutional law that fosters a consciousness of relations of power through perspectives and developments from the Global South. I call attention to constitutionalism from the South not as an academic pursuit, but in some sense as an intellectual disposition that values knowing with. Southern constitutionalism offers a perspective on the field of comparative constitutional law, expanding its vision and really acknowledging how much we have to learn. I use the term to draw attention to relations of power and to perspectives from the Global South. So I'm acknowledging here the histories and the present state of global inequalities in the way that, I guess, needs to influence our understanding of constitutionalism. Now, I think one reason this is really important is because the dominant approach, as I see it, to comparative constitutional law is in many ways based on a Euro-American idea of constitutionalism. That is, the way we understand constitutional law is often very much influenced by both the experiences of the Constitution in America and the Supreme Court of the United States. as well as to a lesser extent the experiences of the United Kingdom, of Europe, and perhaps also countries such as Germany. And so often the concepts and the terms that we use and talk about have been derived from these particular constitutional experiences that are in many ways based on particular contexts, social, economic, and political. And so the idea of Southern constitutionalism is in many ways to trouble some of these concepts and to try to expand their application. Now, there are two other ideas that some scholars have talked about, and I just want to briefly explain how Southern constitutionalism, I think, differs slightly. So some scholars have talked about transformative constitutionalism. This originates with the contribution of a scholar called Carl Clare in talking about South Africa. And he referred to this idea of transformative constitutionalism to capture the way in which South Africa's constitution-making process really led to a focus on using the constitution and constitutional mechanisms to reform relationships of power in ways that foster democracy and non-violence. But in many ways, this term now has a much broader use, and some scholars have used it to refer to to countries such as Germany and other places. And so in some sense, it's lost its connection to post-colonial contexts. So while I acknowledge that Southern constitutionalism can be transformative, I don't think it necessarily has to be, or that it necessarily is in its essence. Another term that some scholars use is this idea of activist courts. And I think this is one that perhaps many of us might be familiar with. So this idea that in many countries where there is significant socioeconomic challenges, that courts may take on a significantly expanded role, perhaps taking on more of a legislative or administrative role in actually implementing in many ways or monitoring certain policies that lead to socioeconomic changes. And often courts that are referred to in this context are ones such as Colombia or India. And again, this shares, I think, a lot in common with the idea of transformative constitutionalism. So this idea that institutions of the state can be used to pursue social goals. But I think if we're realistic in our approach, we need to come with an idea of Southern constitutionalism that I guess acknowledges both the good and the bad in constitutionalism from the global South, that it's not all about transformation, and that there are some particular challenges in those contexts. So let me turn now then to the third part, which is really to give you a bit of an illustration from Myanmar and to think about, well, what does constitutionalism look like in this context and what are the challenges there? And I think what first becomes obvious is that there were, of course, many challenges for constitutionalism before COVID-19, and many of those continue on to the present. So just briefly, many of you would know that Myanmar recorded its first positive case of COVID-19 in March. It doesn't have a terribly large number of confirmed cases, so I believe roughly around 300 or 400 by now, and a relatively small number of deaths. But it's generally known that the number of cases is probably under-reported or under-detected, and so it's quite difficult to know what the real numbers are. So what has happened in the context of Myanmar? How has the government responded? Well, first of all, there is no constitutional state of emergency. And I think it's important to note this absence, if you like. So the Constitution does provide for emergency powers, but the government at the moment, so the National League for Democracy, has not declared a constitutional state of emergency as a result of the pandemic. And one reason it hasn't done that is because if it did, there were concerns that this would give greater power to the military. And the National League for Democracy government, led by Aung San Suu Kyi, is not willing to take that risk. Now, this is something that we've seen previously in the past few years when the NLD has been in government. So it's not necessarily a surprise that they haven't declared a constitutional state of emergency, yet it's something that I think that's worth noting. So the second then is, What have they done? They've used what's called Section 144 powers, or these are powers in the Code of Criminal Procedure. This is very much a law from Myanmar's colonial legacy. So during the period when Burma was part of the British Empire, many of the codes that applied in India also applied to Burma. And the Code of Criminal Procedure continues to exist in Myanmar in the same form that it did during colonial rule. Now, this Section 144 sort of power, as it's known, is often used in times of conflict in Myanmar. It's been used in Rakhine State, so in the areas where there has been violence against Rohingya. It's been used against protesters or demonstrators, so particularly in regards to things like land disputes. So it's quite common, actually, for local administrators to use this power to impose a curfew, to restrict public gatherings, and to restrict freedom of movement. So the use of Section 144 in COVID-19 actually is not that unusual for Myanmar. And I've referred in some of my previous work to the ways it's almost developed as an everyday kind of emergency. So what else has been happening? What other challenges are there to constitutionalism in Myanmar? Well, I think one that is also similar to other countries across Southeast Asia is that there have been people who have been critical of the government's response to and handling of COVID-19. And some of these critics have been prosecuted and jailed for their criticism of the government or of the military. And there are a number of laws that are being used to target critics of the government or of the military, particularly ones around telecommunications and regulating what people say on Facebook, but also particularly targeting journalists and artists and editors. Another trend that I think we see is that in efforts to regulate and contain the pandemic, we see the role of the military. And again, I think this is something that's not necessarily different, that is similar with Myanmar and other countries in the global south. The military in Myanmar in particular has used COVID-19 to try and foster and gain public support, particularly because they know there's an election coming later in the year. Aside from that, or if we think about the role of the military and where else it's working, you might be aware that the United Nations Secretary General actually did call for a ceasefire earlier this year in recognition of the common threat that COVID-19 poses. Now, how did the Myanmar military respond to this? Well, in May 2020, they did declare a ceasefire in areas of Myanmar where there is fighting, but they made some exceptions. And so basically, the exceptions that they made in many ways excluded some parts of the country where fighting is perhaps the worst. And so yes, there was finally acknowledgement of a ceasefire, but perhaps it certainly didn't go far enough. Now, finally, what role did the courts play in all of this? I think it's useful to keep in mind that certainly in many countries, the courts are acting as a check on power and on the powers that the government is using during this pandemic time. Certainly in Australia, there have been challenges, court challenges that are taking place on things like whether the governments are able to close their borders and whether that's allowable constitutionally. But in Myanmar, like in some parts of the global south and Southeast Asia in particular, I think we really see the courts are absent. So the Constitutional Tribunal and the Supreme Court are not really playing a role at all as a check on power. So they're not being asked to review measures of the government to consider whether they're constitutional or not. And if anything, they're being asked to enforce some of the regulations that the government has been put in place. So when people are caught allegedly breaching these regulations, the courts are then asked to decide and hear these cases. Now, on this issue of enforcement, I think it's another one where there are challenges. And in Myanmar in particular, there's certainly been an uneven enforcement of regulations, but uneven also in terms of questions and claims about discrimination. Now in Myanmar, that's taken place along religious lines. So there have been concerns that perhaps Muslims or Christians or other minority groups have either been unfairly targeted or given disproportionately harsh punishments, as opposed to Buddhists who might have been caught out breaching the regulations under COVID-19. So these things I think are important to pay attention to. Finally, I think it is worth noting in terms of government capacity. So one of the things that's often talked about in scholarship on the Global South is, I guess, the very real challenges that governments face in being able to, in the limits that they have, in being able to provide services to people, basic services, access to water, access to food, health services, and so on. And obviously at this particular time during COVID-19, these are services that are essential. And in countries like Myanmar, they're simply services that in many places the government simply cannot or does not provide. And so there's a very real concern for people's well-being in those places. So what I've tried to suggest today from this kind of brief example of the case of Myanmar is that the challenge for constitutionalism there is not so much about constitutional emergency powers or the abuse of constitutional powers, but in many ways the everyday kinds of emergency that are being used, and the way that the current situation is a threat in terms of possibly being an advantage for the military and its popularity in the country. Let me just conclude with a few thoughts. I think what the case of Myanmar helps us to understand is some of the very real pressures on constitutionalism in the Global South. And certainly what I would say is that in many ways, COVID-19 was not necessarily the reason or the trigger for this. I think there was certainly what I would call an illiberal turn in Southeast Asia, and particularly in countries like Myanmar. But COVID-19 has in many ways strengthened this trend. In Myanmar, I think what we see is the existence of post-colonial modes of emergency. So I've illustrated that through the Section 144 orders and the way that local administrators in Myanmar use these orders to impose curfews and restrict movement. I've highlighted the role of the military, and I think that's something that we can see across other places in the Global South. Now, I should say, of course, that even in countries like Australia, we have certainly had the military and police as well involved in efforts to regulate behaviour around COVID-19. But I think often there is the underlying assumption or reassurance that the military will return to its place after COVID-19 ends. I think the challenge for countries like Myanmar is that the military remains in parliament, it remains in the executive, and there is a question about whether it will retreat at the end. Finally, I've tried to highlight today that there are pre-existing inequalities, and so for countries where governments are already stretched, COVID-19 places new and unexpected pressures on governance. So I look forward to questions and discussion, and I hope that has illuminated something about ideas of the Global South and Southern Constitutionalism, as well as the case of Myanmar in particular. Thanks.
Thank you very much, Melissa, and very amazing presentation. In that 20 minutes, you described some of the key words of Southern theory. And let me mention some of the important ideas that you presented this morning, that Southern constitutionalism builds on earlier developments in post-colonial studies, in subaltern studies. And it's because in the field of this law, less attention has been paid to the idea of the Global South, because the mainstream idea is much more influenced by the Europe and US experience. And you also mentioned that it calls attention to political location, relations of powers, experience of Myanmar, and you mentioned about the role of military. So if there is anyone in the participants would like to ask questions in Bahasa Indonesia, and feel free to write the questions. So maybe you want to have an interaction with Melissa, but I would like to start with criticism of this concept, Melissa, if you don't mind. So reading your paper, and I have the privilege to read your paper even before it published. One of the criticisms against the Southern theory in the Global South is it's over-inclusive. It includes 160 out of 195 countries, as you mentioned in your paper. So that's a sense of shared experiences. And I think we all agree that it is not an easy task to find shared experiences and common knowledge between the countries. And you mentioned about the role of military in Myanmar. And perhaps we can also describe about that in the current situations in Indonesia when we deal with the COVID-19, where the role of military is quite high. What do you think, Musa?
Thank you, Milda. So I should say that, of course, Milda did her PhD on Southern criminology, and so I think there are some shared interests and concerns that we have there. I think you're right, Milda, to point out that criticism, and there've certainly been other criticisms of this idea. But I think for me, what it comes back to is that it calls attention to power dynamics in a way that is often overlooked, or in a way that is sometimes underappreciated. And I think, so if we're talking, for example, about courts in the region, whenever I have the opportunity and privilege to work with courts in the region, I'm struck by how much they're asked to do, but yet how little they have in terms of resources, and the different relationship they have to branches of government, whether that's the executive or to the police, or to the parliament. And so I think we need to be careful not to come with certain assumptions about how government functions or how courts function or the role that judges play. And so the Global South is just a useful way to kind of remind us, I guess, and particularly people like myself who are not based in the Global South, of the kinds of things we need to be conscious of when we're studying constitutionalism in other places.
Yeah, excellent, thank you. Is there any questions from the participants? I think Elena has some question. Elena, could you please?
Yeah. Thank you, Milda, for the time, and thank you, Melissa, for your what can I say, like enlightenment, because I don't really understand about this theory, the global northern and the global south, until Milda and you especially explain it to me what is meant. Actually, what I want to ask is about how do you what is your opinion on this theory if applied in Indonesia, in the context of Indonesia, and then also related to the politics of religion, the majority of religion in Indonesia, like Islam, maybe related to this theory. What do you think? Maybe because this adds some uniqueness, if I can say, like specialty. What do you think about that? Thank you, Melissa.
Yeah, thank you, Lena, and lovely to have you along today. So I think for Indonesia, we've obviously seen some, maybe we can say, conflicting responses from the government to COVID-19. As I mentioned before, on one hand, the national government, unlike India, decided not to have a full lockdown, but of course that caused tensions with various local level officials, governors, and so on, who did decide to have a lockdown in part or in full. But I think now, in many ways, some of those restrictions have been lifted, and while there are certain health measures in place, and it remains an ongoing concern, it's quite a different approach to other contexts. So, you know, for example, in Australia at the moment, Melbourne is in lockdown because of the number of cases they have there. What I think was useful in the context of Indonesia was to see that the courts did play some role. So when the president issued the Perpu, and there were, I think, some NGO groups who took the case to the MK as a way of, you know, challenging and questioning, can the government do this? Does the president have the power to, you know, the particular issue was, you know, officials who were involved in, I think, handing out funding to people during COVID-19 couldn't be criminally liable in any way. So there were concerns that that would lead to corruption or maladministration. And so I think it's, Indonesia is, I guess, one example of a context in the Global South where there are some checks and balances on executive power, and where civil society does have space to be able to raise those questions and concerns in an official legal forum and have them heard. Now, I think the challenge, though, is that there are, of course, still some shared challenges that Indonesia has in a similar way to Myanmar. So, for example, government critics. I think, you know, there have been a number of different people, academics as well in Indonesia, who have raised concerns about how the government is handling COVID-19. And seeing ways in which they are perhaps at times targeted is, I think, quite worrying and troubling for freedom of expression in Indonesia, and for people, you know, who want to ensure that government is using public power in ways that benefit society. So I think that targeting of government critics is particularly challenging for Indonesia at this time. But I think more broadly, there's a long-term perspective in terms of, well, where do we go from here? How does sort of constitutional law and legal mechanisms and rights protection help to ensure that people have health services that they need, the sort of public education and knowledge that they need, the access to information to be able to make good decisions. I think all of these are really big challenges that will remain for maybe months, maybe more, we don't know, for governments around the world. Thanks.
Thank you, Melissa. I also have a question related to your last statement, but maybe I'll ask you later. So we have a question from Ibu Riana Susmayanti, and because she's not available to ask directly to you, so I will just read it. Related to hoax, do you agree that limitation freedom of speech should be mentioned in Constitution? What literature that you suggest to analyze hoax versus freedom of speech? Thank you. So I think she wants to ask your opinion related to whether or not freedom of speech should be mentioned in the Constitution, yeah, and how to, what kind of literature, and can we use this Southern concept to analyze how to balance between hoax and freedom of speech? Melissa.
Yeah. Thank you. So I think, you know, the concept of hoax, of course, is somewhat unique to Indonesia, but at the same time is not, in the sense that, of course, there are many challenges for freedom of speech in many countries. And I think you're right to identify that this is certainly one of those challenges. And I think it is a big challenge because there's, I guess, first of all, there's a question of how much should the government be involved in limiting or monitoring certain kinds of speech. And I think it is a challenge because in many ways, for a government to be credible, they need to allow different voices and different views and different opinions and questions to be asked of them, and concerns to be raised, because that's the nature of a democracy. And so for me, I guess this broader issue of hoax and its relationship to freedom of speech is one of the challenges for democracy in Indonesia going forward. It is a challenge, I think, constitutionally, and yeah, is one about a question about whether and how much a government should be involved in regulating free speech. Now, I appreciate that, particularly when it comes to the pandemic, we want the public to have access to reliable information, to information that can help them make good decisions. But at the same time, if it is, this idea of hoax can't simply be used to silence political opponents as and when a government chooses. So there is, I think, a really fine balance there between those two things, and certainly one that many other countries are dealing with.
Thank you. I think some of the questions addressed in this virtual chat are actually about Indonesia, Melissa. So although you presented from the view of Myanmar, but I think we really would like to hear from your thoughts about the current situation. So I hope you don't mind, because I have a few questions here. The first one is from Pak Kustan. Is this notion of Southern Constitutionalism coherent in its nature? If its coherence is located on the post-colonial context and the geographical fact of Southern Hemisphere, then it is rather unfair to exclude countries like Australia, New Zealand, and other Commonwealth countries in the Global South. Had there been no military dominance in Myanmar, would Aung San Suu Kyi exercise this Section 144 power during this pandemic? Thank you, Professor Crouch. So I think it's related to the terms and the definitions and the limitation of what we call the Global South and the Global North, Melissa?
Yeah, so I think there are two questions there. So on the first one, which I think is kind of about settler colonies like Australia, and I certainly acknowledge that we have a long way to go in Australia to address some of the injustices of the past. Australia is the only Western liberal country in the world that has not recognised Indigenous people in its constitution. And so certainly there is still an ongoing campaign to try and ensure that we respectfully and rightfully acknowledge Indigenous peoples in our constitution. And that's certainly something that we have a long way to go on. So what I do just want to say on this idea of whether the Global South is coherent. So some scholars like John and Jean Komarov have certainly acknowledged that it is not so much that it's not really geographically coherent. It's not really meant to be confined to a particular geographic place, but is simply a way of acknowledging that there have been particular contexts where I guess colonialism and then the effects of globalization have had a much more intense effect than others. And they even then go on to talk about things like the concept of the South in the North. So this idea that, there will be particularly kinds of disadvantaged communities in the global North. And of course we see that, of course, there is huge inequality in the global North as much as there is in the global South. And so I would agree with you in that point. On your second point, which was more about Myanmar and Section 144, and a question about the role of the military. So I think, the challenge is that at the moment, the Constitution is part of the problem rather than part of the solution. And so the Constitution includes a role for the military, not just in Parliament, but also in parts of the executive, and in many ways informally in a lot of aspects of government administration or the courts. And so when Aung San Suu Kyi and her government, the National League for Democracy, formed government about 5 years ago, they were coming into really quite a difficult and unusual situation. And so it's quite hard to say, well, what if the military wasn't dominant in Myanmar? Because I think for many people, that's a difficult thing to imagine, even though it's one that many people would like to work towards. The Section 144, you're right, though, is to some extent connected to the military in the sense that government administrators who issue these orders at times may have some connections to the military or may perhaps be former military officers. I think overall, though, there's I guess the broader point that I was trying to make is that Section 144 is a power from colonial rule. It was a power that British administrators used, particularly when there were conflicts and riots against Indians in Myanmar. But it's one that's stayed on and persisted and is now used in different ways by subsequent governments. And I think COVID-19 raises a challenge because it has perhaps expanded the use of this particular power, and one that in some sense goes unrestricted or unchecked by constitutional principles.
Thank you. I think I need to mention about Rywin Connell, who is an Australian. She is the one who proposed the Southern theory in sociological fields. And then there's also Kerry Carrington, who is also an Australian. She's the one who proposed a Southern criminology, the perspective that I used for my thesis. So I think I agree with Melissa and Pak Kustan as well. There are a few questions, but we only have 7 minutes left. Melissa, I'm trying to wrap up everything, but there's also Dr. Muhammad Uhaib, who would like to ask you and give comments on your presentation. Bapak Muhammad Uhaib, monggo silakan Pak. Ada yang mau ditanyakan ke Ibu Melissa?
Okay, thank you very much. I would like to thank you to give your opportunity to asking direct question to Prof. Melissa Cruz. Well known under Suharto's government, the dominated military in Indonesia, expansion and social and political life and economic life, and to bulk clientelism between politicians and businessmen. Analysts Helker Suharto's the military very dominant to hijack and social and political life. What your critical point about the recent time under Jokowi's government today about democratization in Indonesia after crackdown regime Suharto? What your comment about the practical of democracy in Indonesia today? Today, very democracy is very dangerous today. The rise of a local oligarchy, the right and political dynasty, and a political practice in Indonesia. What you compare about the practical political life between Myanmar and Indonesia? Indonesia is well known in the world the most important democracy today, but in the real practice, Indonesia is not most good practice democracy today. Indonesia is very under pretext of oligarchy, the many oligarchs to hijack democracy today, and beside the Jokowi, it is very bad democracy implementing democracy today. What a comment about the practical democracy today in Indonesia? Thank you, Prof. Melissa Cruz.
Thank you, Pak. So you've raised a very good point, and I think you're right that democracy in Indonesia is perhaps at a very critical stage. Of course, in the early years of Reformasi, we were mostly focused on the elections, and the elections are really important, and having a sort of consolidated democracy in terms of two national elections that were considered to be free and fair was an important milestone. But I think what you've suggested and highlighted is that there are some particular challenges to democracy now, both in terms of perhaps the way that minorities are treated, I think, which has been a challenge that has been ongoing for some time and something that my own research has looked at in terms of religion. But also now, perhaps just more broadly, the way that law in particular is being used and is being politicized against political opponents in ways that undermine democracy and its ideas of free speech and free expression and debate and discussion. And so, yeah, I would agree with you that I think it's a critical time, and I think COVID-19 places additional pressures And it places additional pressures because on one hand, the government has a justification to take extraordinary measures, right? Because it is a pandemic, and to some extent that does require extraordinary measures. But at the same time, it places a challenge for, I think, civil society and academics and others to keep watch on what the government is doing and to raise questions when there are concerns about the direction that it's going in. And I think this will be a really testing time, and certainly a testing time for many countries who very much have aspirations for democracy, or who have made a transition to democracy, but are now facing those challenges of potentially a backsliding. And of course, there's a lot of scholarship and discussion at the moment on this concept of the decline of constitutional democracy. And I think that's something that is also a challenge for Indonesia.
Excellent. Thank you so much, Melissa. There are 3 questions left. I would like to ask you, like, how many minutes, maybe 5 minutes more. Do you mind, Melissa? Yeah, so in order to answer these 3 questions, the first one is from Pak Morusianipar, and I hope this will be like the 3 questions will be the last one because we're running out of time. The first is from Pak Morusianipar. Hi, Melissa, I'm Morus from Jakarta. I would like to know what is common in Southern Constitutionalism regarding the response of government in handling COVID. What is the level of emergency they're applying? I'm referring to proportional necessity and how they manage the set of regulation issued to handle the situation in terms of presidential regulation, or we call it as Perpu. And then the second question is from Ibu Patricia Audrey. She would like to know how the context of Southern Constitutionalism or Southern theory to be applied in international law. And I think we all know, maybe you know about the TWIL, the Third World International Law approach. And then the last one is from Bapak Aji Ramdan. I have one question for Melissa. What's your opinion about Rohingya massacre in Myanmar? Is it a part of military dominance? Thank you.
Great. So thank you, Milda. And given that they're quite diverse questions, I might just try and take the common thread, perhaps, from among them, which is concerns about, I guess, international law and human rights. And so you're right, Milda, that TWIL, this idea of third world approaches to international law, is something that is quite well established as a scholarly field, and is a way that scholars have tried to critique international law and to expose some of its perhaps biases towards the global north. And so I think in a similar way, this is what Southern Constitutionalism, the idea of constitutionalism from the global south, is trying to do. On the Rohingya situation in particular, and it's perhaps to end the seminar with a fairly sober note. So I think we are facing particular challenges now for displaced communities, precisely because COVID-19 means that there is no movement or there is no possibility of return at this particular point in time. But certainly at the moment, it is a combination perhaps of both the role that the military has played in this context, as well as the challenges that the NLD government faces in addressing this and in responding. And of course, there are many in the international community who would say it simply hasn't been enough. It hasn't. And prior to COVID-19, there certainly weren't sufficient efforts being made to genuinely ensure that people had a right to return. And so I think COVID-19, again, places some very real pressures on human rights situations such as the Rohingya, most of whom are now in parts of Bangladesh, and will pose a challenge for the international community in terms of how it works with Myanmar to try and address this situation in the long term. It's certainly one of the biggest challenges in the region, I think, at the moment. But I'll leave it there. Thanks, Walter.
Thank you very much, Melissa. So there are lots of topics, a wide range of topics that you presented this morning, from Southern Constitutionalism to COVID-19 to the fall of democracy in Indonesia and the human rights situation in the regions. On behalf of the Faculty of Law, on behalf of the Dean of the Faculty of Law, I would like to say thank you very much for giving us this excellent presentation and discussion. We do hope that this is not the last. We do hope that we will see you again in other topics, another discussion. And I also would like to say thank you to all of the participants. You may want to see the record of this discussion in YouTube channel on the Faculty of Law, Brawijaya University. Thank you very much, and I'll see you next time. Goodbye, everyone. Thank you, Nalisa.
Thanks, Mula. Terima kasih.
Bye.
Menggunakan pesawat